Good evening, my name is Sam Bass and I'm a professional engineer. Hello? Is it working? Is it on? Okay, perfect.
Oh, so the witness needs one up there?
That's why she's got one. Hey,
Okay, gotcha.
So the witnesses, why do we have two microphones on each side? Oh, okay, so you're tied into the microphone up there, or is there one up there? Is there a microphone up there at the? Okay, okay, so the microphones stay up here with the lawyers, and that way it's just gonna be switched a couple of times. Okay.
Great.
So it's
That'll
fine
make
if I
it
just
much,
leave
much
it on?
easier.
So it's fine if I just
Yes,
leave it
if you're doing second witness and pretrial, leave it on. So whoever goes first and whoever goes second will wear the microphone.
All right.
And then when the first one is done, you slowly transfer the other to the.
And I think we're going to give our witness input for instructions.
I would aim it. Let's see.
Because it's far away.
I don't know. I would just, yeah.
Oh, like put it right here?
Yes,
Okay.
you want this to be attached.
Okay, okay, okay.
We can, if you want to put it on the outside.
Okay, thank you so much.
Because if it's up against your fabric, it's gonna run.
Okay. I think that's okay.
And we don't want that, no, that's perfect.
Okay, perfect. Thank you so much.
Everybody take your lanyards off, just lose those things. That always gets in the, you can leave. Everybody, I want him to wear his lanyard.
Remember her style from last time? She's,
Because the one thing that's gonna
Gisela,
run on that microphone.
can you put mine by my bed?
Forward. And
Just set it somewhere over there.
Yes, sir.
you guys are
Or we're F.
N versus
So testing.
these are 13. I think that should be enough. Give me one of the.
I was enjoying going through it. Just be quiet.
Nope.
Just relax.
I know it's hard for me.
Okay.
And we're not going
I go like this.
to say you need to.
Yeah, we're all with us. Oh my God, I'm pretty sure.
So that you guys know you finished.
We have to remember to still be
So you both have to figure. Neither of these teams has lost.
Great.
Sadly, that's not the change.
Right.
Wait, are you serious?
Like
Did
actually?
we both finished 4-0? I thought that we went like 2-2.
That is a great confidence boost.
Nice.
You wouldn't be here.
Well, yeah, but like,
No, we were sitting there and we were like, damn, we got like 17th.
yeah. I started crying when they called us. It was a moment that I thought we weren't gonna play. No, yeah.
No, she said they thought they did.
Oh, okay.
So we did beat Booker. We knew that.
We left.
I mean, 3 or 4 now it comes to that.
We left New York Truck Lots. Thank you for the word.
I think
It's pretty good. I think I like the decor in here better than some of our other courtrooms.
very much for this.
Please. Thank you. Appreciate you.
Do you remember,
We're fine.
you know the kids museum in Fort Worth?
Okay.
Like science and history museum? Do you remember that little movie theater that you go into the tunnel, the underwater tunnel, and then you go into the movie theater, and then it's about dinosaurs and natural gas? That looks like those movie theater seats.
It's like barely there.
Oh, I loved that museum as a kid. So much.
There we go.
We went 4-0.
Does everybody have the exhibits they need?
Oh, this one's nice.
We just won. Okay.
Everybody have, not you guys. Does everybody have exhibits they need?
No.
They baked it though. Hold on. You have all the exhibits you need.
I need maybe some Victor's
We
fit
need
it
to
now.
get those out.
Okay.
Yeah, pop them out.
Go
But
ahead
like,
and get them out so we don't have all the
but remember to retrieve exhibits at the end of your examinations, please. I'll do it. I'll try and.
Oh, I think that's there.
Table clean. I also have this here. Leave it just in case. Just do one of these.
Okay, what are the 3 names?
Texoma is now in session. The Honorable Lana Myers presiding.
Please be seated. Good afternoon. I'll call the case. It's cause number 22-0213, style the State of Texoma versus Bon E. Barrow. Is the state ready?
Yes, Your Honor.
And is the defendant ready?
Yes, Your Honor.
All right. If just a few matters before we get started, make sure that all electronic devices are off. All right. And if you would now, starting with the state, if you would please introduce yourselves, state your name and the role that you play.
Yes, Your Honor. Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Maya Silberman, and today I'll be conducting the direct examination of Kenton Kane and the cross-examination of Sam Bass.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Nivi Manikanden, and today I'll be conducting the direct examination of Del Boone, the cross-examination of Gil O'Nothan, as well as delivering the state's closing argument.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Ava Boswell, and today I will be delivering the state's opening statement, as well as conducting the direct examination of Jess Newton and conducting the cross-examination of Bonnie Barrow.
And now our witnesses.
Yes, please.
Good afternoon, Your Honor, members of the jury. My name is Jackson Price, and I'm Jess Newton.
Good afternoon, Your Honor, members of the jury. My name is Kishan Sargur, and I am Dr. Kenton Kane.
Good afternoon, Your Honor, members of the jury. My name is Gisela Rivera, and I am Del Boone.
Thank you. You may be seated. Now, if the defense would please introduce yourselves and state the role that you each play.
Yes, Your Honor. We are Defense Team F. My name is Jonathan Fredericks. I will be directing Bon Barrow, crossing Kenton Kane, and delivering the closing argument.
My name is Ellie Monwai. I will be directing Jill O'Nothan and crossing Del Boone.
My name is Emerson S. Bennett. I will be delivering the opening statement, directing Sam Bass, and crossing Jess Newton.
And may our witnesses introduce themselves?
Yes, please.
My name is Sophia Foster, and I am Bon Barrow.
My name is Sachi Monwai, and I am Jill O'Nothan.
My name is Nancy Jagaman, and I am Sam Bass.
All right. And if you all would please remain standing, and then if I could have the state's witnesses please stand, and would each of you now please raise your right hand and take the oath. Do you promise that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
All right, thank you. You may be seated. Are there any preliminary matters that we need to take up at this time?
Yes, Your Honor, the prosecution does have some pretrial matters that we would like to attend to.
Go
First,
ahead.
would you like a courtesy copy of the rules, stipulations, and exhibits?
I have those. Thank
Yes,
you.
Your Honor. Now, regarding movement about the well, may we move about the well during opening and closing statements as well as direct and cross-examinations?
You may.
We also have some exhibits we would like to pre-admit. First, we would like to pre-admit Exhibit 1, as it has been stipulated as admissible pursuant to Stipulation 14.
All right. I recall that, and Exhibit 1 is admitted.
Yes, Your Honor. We'd also like to acknowledge that pursuant to Stipulation 18, Exhibit 5, Detective Lars Wilson's deposition has been pre-admitted, barring any objections. And we would also like to acknowledge that pursuant to that stipulation, either party may read or reference portions during examinations.
Yes, the court recalls that in the problem, yes.
With that, Your Honor, the state is ready to proceed.
All right. Are there any preliminary matters that the defense would like to take up at this time?
Yes, Your Honor. During objections, may we approach constructively from our tables rather than actively at the bench?
Yes, please do.
With that, the defense is ready to proceed.
All right, thank you. All right, is the state ready to present your opening statement?
Yes, Your Honor. May I proceed, Your Honor?
You may.
May it please the court, opposing counsel, and members of the jury. Actions have consequences. You'll see that the actions of the defendant Bonnie Barrow on the night of March 12, 2022 had deadly consequences. My name is Ava Boswell, and I, along with my co-counsel, Nivi Manikandon and Maya Silberman, represent the state of Texoma in today's trial. Today, the state of Texoma charges Bonnie Barrow with both attempted kidnapping and felony murder. Members of the jury, you'll see that this case started with a plan that was not only faulty, but both reckless and dangerous. You'll see that Bonnie Barrow had a plan to forcefully kidnap Kenton Kane at gunpoint. The evidence will show that on the night of March 12, 2022, Jess Newton and Bonnie Barrow took it upon themselves to make a citizen's arrest of Kenton Kane. Members of the jury, Texoma law, however, does not allow one citizen to arrest another. So what Miss Barrow attempted to do was kidnapping, plain and simple. You'll then see that Miss Barrow then engaged in a reckless and high-speed car chase of Kenton Kane. Now, members of the jury, the defendant's actions had consequences. And the consequences of Miss Barrow's high-speed car chase was Kenton Kane crashing into construction scaffolding, knocking the bricks that lay above it onto Miss T. Deely, crushing her to death. Now, members of the jury, today as the prosecution, we have the burden of proof. And we will prove to you beyond a reasonable doubt that Bonnie Barrow attempted to kidnap Kenton Kane using threat, force, intimidation, or violence. You'll also come to see that both death and injury were natural and foreseeable consequences of none other than Miss Barrow's chase. To meet our burden, the prosecution will introduce 3 witnesses today. First, you'll hear from Jess Newton, an accomplice of Miss Barrow's plan. Now, Mr. Newton will testify that the pair only left the crime scene just as law enforcement began closing in on them. You'll also hear that the pair was still in the alleyway just as Kenton Kane had crashed. And you'll actually hear from Kenton Kane himself. Mr. Kane will tell you how Miss Barrow tried to forcefully stop him on the road, how he was approached with a gun and zip ties. And members of the jury, after hearing his testimony, I'd like you to ask yourself, how did Bonnie Barrow expect anyone to act during an armed car chase? And finally, you'll hear from TBI helicopter pilot Del Boone. Miss Boone had a view of the chase for almost the entire night and will testify as to the defendant's recklessness that she observed from the skies. And now you may be wondering at this point, what does the defense have to say? They can't argue that what Bonnie Barrow did was not incredibly reckless and dangerous, so we anticipate that they will raise the defense of voluntary abandonment. Now, the defense may try and argue that the defendant voluntarily abandoned this chase before Kenton Kane crashed. But members of the jury, I'd like you to keep in mind that a defendant does not voluntarily abandon a chase if she does so out of fear of law enforcement. The defense may also try and prove that other factors were responsible for the death of T. Deely, but members of the jury, I ask you again, would any of these factors have mattered if not for the extremely reckless and dangerous car chase led by Miss Barrow? Now, we anticipate that the defense will also introduce 3 witnesses. We expect that they'll call the defendant herself, Miss Bonnie Barrow. Miss Barrow will be forced to admit that her chase was incredibly dangerous and that she only left the crime scene just as law enforcement closed in on her. We expect that they'll also call Guilty O'Nothan a faulty eyewitness at best. Miss O'Nothan did not see the beginning of this car chase. She did not see Bonnie Barrow chasing Kenton Kane up and down the streets of downtown Texoma. We expect that they'll also call Sam Bass, who's being paid a considerable amount to testify on the defense's behalf today. Now, Ms. Bass's testimony will miss the obvious point in today's trial, which is why Kenton Kane crashed into the scaffolding. Kenton Kane had to get away from the threat, which was none other than the defendant herself, Miss Bonnie Barrow. Members of the jury, Bonnie Barrow's actions had consequences on March 12th. And after hearing all of the evidence today, you will have no doubt in your mind that Bonnie Barrow is guilty of both attempted kidnapping and felony murder. Thank you.
Defense, opening statement.
Yes, Your Honor, may I proceed?
You may.
Your Honor, opposing counsel, members of the jury. Many of us grew up hearing the story about an old woman who swallows a fly. There was an old woman who swallowed a fly. She swallowed a spider to catch the fly. She swallowed a bird to catch the spider. She swallowed a cat to catch the bird. And ultimately, she swallows a horse. And after swallowing this horse, she dies. Now, at first glance, this might seem like a chain reaction, but no one would expect that after swallowing a fly, the old woman would go on to swallow a bird or a cat, let alone a horse. Today, the government is trying to frame disconnected actions as a chain reaction. They will tell you that the defendant started this chain reaction that ultimately led to the death of an innocent pedestrian. However, just because one action is associated with another does not mean that the first action caused the second action. Correlation is not causation. Now, the defendant, Miss Barrow, is an ex-Marine, so when she found out that here in Texoma there lived a major arms dealer who was funding an unjust war, she decided to take action. Not long after, her friend and fellow ex-Marine joined her, and you will hear how on March 12th, they initiated a car chase to capture this arms dealer. However, after about 17 minutes of the chase, the defendant decided to go home. Even though he was no longer being chased, the arms dealer continued to drive recklessly, speeding well above the speed limit on his cell phone with his headlights off. Not long after, he lost control of his car, hit some scaffolding that was on the sidewalk, and the brick pallets that were on top of the scaffolding fell. One fell on the arms dealer's car, and another fell on an innocent pedestrian. Now, Ms. Boswell just told you that actions have consequences, and they do. But the person who hit the scaffolding, the person who did the action, was Mr. Kane, not Ms. Barrow. We all agree that Ms. Barrow initiated a car chase. However, there are too many unforeseeable things for the crash to be a result of the chase. First, the evidence will show that the arms dealer was driving recklessly after there was no longer a threat to his life. Nobody could have foreseen the old woman swallowing a bird, and nobody could have foreseen this arms dealer's reckless driving. Second, in Texoma, it is illegal for brick cubes to be left on top of scaffolding units overnight. Nobody could have foreseen the old woman swallowing a cat, and nobody could have foreseen these brick pallets being illegally left on a scaffolding unit. Finally, scaffolding units in Texoma are closed off, and it is extremely difficult for a pedestrian to end up underneath one. Nobody could have foreseen the old woman swallowing a horse, let alone dying from it. And nobody could have foreseen a pedestrian being under a closed-off scaffolding unit, let alone dying from it. Now, to prove felony murder, the death must be natural or foreseeable. Members of the jury, nobody could have foreseen these things. So how was Ms. Barrow supposed to have foreseen them? Now today, we as the defense have taken on our own burden to prove to you two things. If we can prove that it is simply more likely than not that Ms. Barrow went home and abandoned the chase, she cannot be held responsible. Second, unfortunately, after Ms. Barrow was arrested, evidence that would have proven her innocence was recklessly destroyed by a TBI officer. And so today, we have taken on an affirmative defense to prove to you that this was recklessly destroyed. And when we do, You must find that this evidence would have aided the defendant. Members of the jury, when the government tries to frame disconnected actions as a chain reaction, remember that correlation does not equal causation. This death was tragic, but unforeseeable. And that is why we will ask at the end of today's trial that you find Ms. Bonnie Barrow not guilty. Thank you.
Will the state please call your first witness?
Yes, Your Honor. The state calls Jess Newton to the stand. May I proceed, Your Honor?
You may.
Good afternoon, Mr. Newton. Today I'll be asking you some questions. Now, please go ahead and introduce yourself to the court.
My name is Jess Newton, and I'm 28 years old. I'm currently working for a private security company called Rexford Solutions.
And Mr. Newton, how are you related to the case at hand today?
Well, I was best friends with the defendant of the case, Bon E. Barrow, and I was also present with Bon on this crazy car chase you've heard about.
And I'd actually like to talk a bit more about that car chase. Why were you involved in this in the first place?
Well, sometime in February of 2022, Bon came to me ranting about this huge invasion between two countries that I'd never even heard of, and she seemed pretty angry about it.
Did Miss Barrow ever take any action to do anything about this?
Well, I learned from her that she was taking the week off of work starting on March 7th, and I didn't think anything of it at the time, but I ended up calling her on Wednesday of that week just to check in, and that's when I learned about this whole stakeout.
And what was this stakeout?
She was staking out some guy named Kenton Kane. Apparently Kane had something to do with this whole crazy invasion thing. She said that Kane had to be taken down.
And Mr. Newton, how did you react to learning this?
Well, this sounded a lot like kidnapping to me, so of course I tried to talk my friend out of doing anything that she would regret, but I could tell she just wasn't listening to me, so I decided that I was going to join the stakeout in order to prevent any further damage that might be caused. I ended up joining the stakeout on March 10th.
And Mr. Newton, what happened when you first joined this stakeout?
At first, she was throwing around words like sniper rifles, car bombs, termination, but I managed to talk her out of killing Kane.
What plan did you talk her into instead?
I had brought some police-grade zip ties with me from work that I suggested we use to restrain him instead. That's when she proposed we perform a citizen's arrest, and we came up with our new idea from there.
And Mr. Newton, what was this new idea?
The idea was for us to arrest Kane and turn him over to the proper authorities. I did not agree to anything that happened after that.
What happened after that?
Well, the first time we saw Kane was that Saturday, March 12th, just before 8 o'clock that night. He was leaving his house in this fancy sports car, and Bon seemed pretty excited about it. She said it was our chance to grab Kane.
And how did you react to this?
I was pretty sure we had not thought the plan through enough, and so I suggested that we go home instead, because I thought that someone was going to get hurt.
How did Bon react to your suggestion?
Well, before I could get more than a couple words in, we were already following Kane.
Where did you follow Kenton Kane's sedan?
We followed the sedan up onto the Riverside Highway headed east. Kane kept driving pretty normally for a while, and then eventually we followed him as he exited on Larkin Avenue and came to a stop at a red light.
Your Honor, permission to approach the witness with what has been pre-admitted as Exhibit 1.
You may.
Mr. Newton, what is this document?
This is a map of Texoma City.
Your Honor, permission?
Your Honor, I would ask to see the copy of Exhibit 1 that's going to the witness.
Show it to opposing counsel.
Thank you.
Now, Mr. Newton, once again, what is this document?
This is a map of Texoma City.
Your Honor, permission for the witness to step down for demonstrative purposes?
He may.
Your Honor, may I reposition myself to see what the witness
Yes,
is
you
showing?
may.
Thank you.
Now, Mr. Newton, could you go ahead and tell the jury where was this red light that you had stopped at?
The red light was right there at Larkin Avenue. We stopped just before 8 o'clock that night.
What happened after this?
Well, that's when Bon yelled at me to get out of the van and grab Kane, but I said we should just go home instead.
How did Bon react to your suggestion?
She started yelling at me. She called me all sorts of names, and that's when I decided that I was not having any more of this, so I was going to leave the van.
And how did you try and leave the van?
Well, I told Bon that I think I'm out. Before I could really leave the van, that's when the light turned green, and she said, "You're in now, buddy," and things got really crazy from there.
Mr. Newton, what do you mean things got crazy from there?
Well, after the light turned green, both cars were stopped right here at this light. We floored on the accelerator and flew up Larkin Avenue. At that point, Bond pulled alongside the sedan as we approached Beta Road right there.
And what happened once you had reached Beta Road?
Well, that's when Bond swerved into Kane's lane and slammed on the brakes, forcing both cars to come to a complete stop.
What happened after this?
Well, this time when he yelled at me to get out of the van, I did so and I approached the sedan.
Now, to clarify, were you able to reach Kenton Kane at this time?
No, ma'am. Before I could tell Kane to get out of the sedan, it actually reversed back down Larkin Avenue right there and then headed down Abbey Road. So I just got back into the van and we kept following Kane.
And where did you follow Kenton Kane's sedan?
Well, later in the chase, I saw the sedan on our right as we were up here passing the Java Coffee. He was on Main Street, so I directed Bond to take a right turn onto Main Street. And at that point, the sedan was actually right in front of us. We were coming at each other, but he took a quick turn left onto Beta Road once again.
And did you and Bond make this same turn?
Yes, ma'am, we made the turn, but it took us a little bit longer than it took Kane, which ended with Bond saying that if this chase kept going on, someone was going to get killed, and she just hoped it was Kane.
Now, Mr. Newton, what happened next after this?
I don't remember all the turns that we made after that, ma'am, but I do remember at some point passing St. Zoe's Cathedral, which is right here, and at that point we turned back north onto Main Street once again.
And what happened after this?
Well, we followed him up Main Street, past Deborah Drive right there, and into this area up here, which is called the Merge.
Did you continue following the sedan after this?
Yes, ma'am, we followed him up on Main Street into the Merge, and then we watched him take a U-turn on Main Street. He was going north, he came back down south, and we ended up making that same U-turn, but we ended up on the curb in order to do so.
And where did you follow the sedan next?
We followed it as it took 4 right turns. It came back down on Main Street, took a right onto Deborah Drive, another right onto Larkin, and then a final right onto Fox. And after that, it waited around a little bit and then darted into this little alley right there.
And did you follow this into the alley?
Yes, ma'am, we did. But after he entered the alley, we lost sight of him. We followed him into the alley and came all the way through to the front of it, stopping in front of Deborah Drive. We did not see the sedan again that night.
Thank you, Mr. Newton. You can have a seat. Now, Mr. Newton, what happened after you had reached Deborah Drive?
Well, at that point, we were stopped, and I looked out my window, and I saw on the pavement a spotlight from a police helicopter, and I could also hear some police sirens getting closer to us.
Now, Mr. Newton, to clarify for the jury, did you and Bonnie Barrow leave the alleyway before or after you heard these authorities?
We waited until the authorities had actually somewhat left before leaving the alley.
And did you hear anything else before leaving the alley?
Yes, ma'am. I heard some pretty distinctive booms in the distance before we left the alley. I didn't know what they were at the time.
Did Bonnie Barrow say anything else to you before you left this alley?
Yes, she said that we should leave and try again at another time, which really made me concerned.
Why did this make you concerned, Mr. Newton?
Well, based on what we'd already been through, it sounded super dangerous to try and do this again.
And why did this sound dangerous to you?
She'd been saying crazy things all night, like using sniper rifles, car bombs, the word termination. She was even talking that if somebody got killed in the chase, she just hoped it was Kane.
And did you end up leaving the alley after this?
Yes.
And what happened on the way back home to your apartment?
Well, she was scanning the road like a hawk, and we took a bunch of smaller roads to get back to my apartment.
What happened when you did get back to the apartment?
Well, that's when she told me that I should just lay low for a while and just not tell anybody about what had happened. So I went inside and I tried to get some sleep that night.
And Mr. Newton, what did you do instead of falling asleep?
I was still a little bit in turmoil about the night's events. At about 11 o'clock, I ended up turning on the television, and that's when I saw that some poor woman had been killed as a result of the car chase.
And Mr. Newton, what did you do after finding out about this?
I didn't know what to do. I went straight to the downtown TBI field office, and I told them everything that I could remember about that night.
And Mr. Newton, what were you charged with as a result of this?
Well, I was charged with conspiracy to kidnapping, but very fortunately, I was granted a plea deal if I would truthfully tell them everything that I could remember, which I did.
And Mr. Newton, will you receive this plea deal if you testify untruthfully in any way?
No, ma'am. I have to tell the truth today, which I have done.
And Mr. Newton, by accepting this plea deal, have you already pled guilty to all elements of conspiracy to kidnapping?
Yes, ma'am. Me and Bond came up with a plan to capture Kane.
Finally, Mr. Newton, why are you here testifying in trial today?
Honestly, I just want justice for that poor woman that died. She should never have been involved in any of the crazy events that Bond created.
Your Honor, we pass the witness.
Cross-examination.
Yes, Your Honor, may I proceed?
You may.
Now, Mr. Newton, like you just told Miss Boswell, you received a plea deal to testify today, correct?
Yes, ma'am.
Would you recognize a copy of this plea deal if I was to show it to you?
I would.
Your Honor, may I approach the witness with what has been previously marked as Exhibit 8?
You may.
Let the record reflect I'm showing Ms. Boswell a copy of Exhibit 8. Now, Mr. Newton, do you recognize this?
Yes, ma'am.
And what is it?
It's my plea deal.
Is it a fair and accurate copy?
As far as I can tell, yes.
Does it appear to have been changed or altered in any way?
No, ma'am.
Your Honor, I now offer Exhibit 8 into evidence.
Any objection?
Yes, Your Honor, as to hearsay.
Response, Your Honor?
Response?
We are not offering this for the truth of the matter, but simply for the effect on the listener. Whether or not the statements made in this plea deal are true does not matter as long as Mr. Newton believes that he will receive a reduced sentence based on this plea agreement.
Response, Your Honor?
You may.
If opposing counsel is asking about Mr. Newton's belief if he will receive a reduced sentence, then that would be for the truth of the matter asserted, as they're using it to prove that he would be getting a reduced sentence.
Your Honor, I stand by that we are not offering this for the truth of the matter that he will receive a reduced sentence. In fact, we do not know whether or not he will, simply for the effect it has on his testimony today.
Response, Your Honor?
I'll overrule the objection.
Your Honor, would you like me to...
The exhibit is admitted.
Thank you. And would you like me to... Can I publish an Exhibit 8 to the jury
You
now?
may.
Thank you. Here are multiple copies. Now, Mr. Newton, this plea deal offers you a reduced sentence on a couple of conditions.
If I tell the truth in trial here today, yes.
So that's a yes to my question, that it offers you a reduced sentence on a couple of conditions.
It is.
One of these conditions is that you testify against Ms. Barrow.
It is, yes.
And even if you testify against Ms. Barrow, though, the state is not obligated to reduce your sentence, are they?
No, they're not.
In fact, this plea deal makes it clear that the state will only reduce your sentence if they are fully satisfied with your testimony today.
Satisfied I told the truth, yes, ma'am.
And the state will only decide if you've told the truth after the jury returns their verdict, correct?
Yes, ma'am.
Now that we've established why you're here, I want to talk to you about your involvement in today's case. It was you, and not Ms. Barrow, to your knowledge, who brought police-grade zip ties to the stakeout.
It was.
And it was you, and not Ms. Barrow, who originally found out where Mrs. Kane was going that night.
I did a quick search on the Me phone while she was in the car, yes.
Now, Mr. Newton, soon after the chase started, it was you, and not Ms. Barrow, who stepped out of the van with those police-grade zip ties to capture Miss Kane.
After she yelled at me, I did, yes.
Now, Mr. Barrow, you and Miss Kane were attempting to perform a citizen's arrest, correct?
That's right.
And it wasn't until today, over 12 months after the chase, that you ever called this citizen's arrest a kidnapping.
It is a kidnapping, ma'am.
That wasn't my question, Mr. Newton. My question was, if today, over 12 months after the chase was the first time you ever called the citizen's arrest a kidnapping, yes or no?
Yes, ma'am.
Now, it was you who had a gun on you that night, correct?
It was in my holster, yes.
Just like you said, you claim this gun was concealed the entire night.
It was concealed.
And so anyone who testifies to the contrary would be lying.
That is correct.
And anyone who happened to testify in court today that you had your gun out would be committing an act of perjury.
Yes.
Now, Mr. Newton, it was you and not Miss Barrow who was tracking the sedan throughout the chase.
That is correct.
And at any point that night during the chase, did Miss Barrow get out of the van?
No.
But ultimately, Mr. Newton, it was Miss Barrow, not you, who made the decision to go home, wasn't it?
That is correct.
Now, Mr. Newton, I want to talk to you about the soft booms that you heard while you were in the alleyway. You heard these soft booms, and then immediately after, you and Miss Barrow left the alley, correct?
Yes, I heard the booms while we were still in the alley.
And it's a yes to my question that you left immediately after hearing these soft booms.
That is correct.
You definitely didn't leave over 10 minutes after hearing these booms, did you?
No, ma'am.
And Mr. Newton, you would agree with me that 5 scaffolding units and over 6,000 pounds of brick falling to the ground would make a pretty loud sound.
Yes, ma'am.
Now, at the time, in the alleyway, you were only about a block away from the crash, weren't you?
That is correct.
Now, Mr. Newton, you wrote your statement on March 19th, didn't you?
I did.
Could you read the date at the top of that plea agreement for me?
March 18th.
So, you signed your plea agreement, and the day after was the day that you wrote your statement to testify here in court today, correct?
Yes, ma'am. I knew that I would have to tell the truth before I wrote my statement.
But that's a yes to my question, that you signed your plea agreement, and the day after was when you signed your statement.
It is.
No further questions, Your Honor. I pass the witness.
Redirect examination.
Yes, Your Honor. Now, Mr. Newton, did you come to the police with your information before or after being offered a plea deal?
I went to the police uncertain if I would receive anything, ma'am. I just wanted to get justice for that poor woman that died.
And finally, Mr. Newton, if you testify untruthfully in any way in trial today, will you receive this plea deal?
No, ma'am.
Your Honor, we pass the witness.
Recross.
No recross, Your Honor.
Thank you. The witness may step down. Call your next witness.
Yes, Your Honor. The state calls Kenton Kane to the stand. May I proceed?
You may.
Good afternoon, Dr. Kane. Please go ahead and introduce yourself to the court.
Good afternoon, everyone. My name is Dr. Kenton Kane.
Where are you from, Dr. Kane?
Well, I'm originally from Robertstown, but currently I live in Texoma with my wife, Wall, and our 2 kids, Cash and Coin, with little credit on the way.
And what do you do to support your family?
Oh, well, I work as the CEO of Graybird SA, a renowned company indeed.
Now, Dr. Kane, let's talk about why you're here today, the events of March 12th. How did that day start for you?
It started with just some early morning Zoom calls with my team after a classic breakfast of baked beans on toast, after which I finished up my workday and then left my home at around 8 p.m. that night.
And where were you going?
I was headed to my good friend Robbie's gala at the Moss Mountain Hotel in downtown Texoma. So I left my house through the south gate, got on Riverside Highway, and reached downtown.
Your Honor, permission to approach the witness with what has been pre-admitted as Exhibit 1?
You may.
Now, Dr. Kane, are you familiar with this exhibit?
Yes, it's a map of downtown Texoma.
Thank you. Now, using that map, can you show us what you did once you got to the city?
Oh yes, I pulled out of the highway onto this road, Larkin, business as usual, and then stopped at this red line on Westway.
Now, what happened when that light turned green?
Well, I continued north, and I had just gotten past Beta Road when I glanced in my rearview mirror, and I saw a white van speeding by me like it was trying to run me off the road.
And what did the van do next?
It swerved into my lane and just cut right in front of me and pinned my car to the curb. I almost crashed, but I braked just in time.
And what did you see after that?
A gun. I saw the driver of the van get out and started approaching me with the gun and zip ties. That's when I knew that I had to get out of there.
And why did you know you had to get out of there?
Well, there's only so many things that you can think when someone cuts you off on the road, gets out of their car with a gun and starts walking towards you, and all that I could think of was that I was about to be kidnapped or killed.
And what did you do next?
Well, my instincts kicked back in, and so I reversed here onto Abbey Road and just got away from them, and I had to get away because I didn't know the lengths that they would go to.
What did you know at that point?
Honestly, I was in a complete panic, and all I knew was that I needed to get away.
And did you manage to get away from the van?
No. I was doing everything I could, but no matter what I did or where I went, every time I looked in my rearview mirror, there was the van.
So what did you decide to try next?
Well, I mean, I didn't know what to do because nothing I was doing was working. And every time I thought I'd lost them, the van would pop up. I'd take a turn, and there they were again. But I saw an alleyway up ahead, so I turned in, turned off my headlights, and prayed that if I just stayed still, the van might pass me by, and I might have a chance to escape.
And is that what happened?
No. Again, the van pulled into the alley, and again it started coming towards me.
And what were you thinking at that point?
The only thing that I was thinking was that I could not let that van catch me. I needed to get out of this alive, and I needed to see my family again.
And what happened next?
Well, as that van was approaching me, I shifted into drive, turned on my headlights, and got out of that alleyway. And as I was leaving, I heard police sirens and saw a police helicopter overhead.
And to be clear, Dr. Kane, when you saw and heard law enforcement, was the van still chasing you?
Yes, they had been heading in my direction down the alley, and I heard the sirens right as I was leaving.
Now, what did you think when you heard the police?
I mean, I was hopeful, but I didn't know exactly where they were, or exactly how long it would take them to catch the van, so I just kept driving, kept going, so that the van would not catch up to me.
And what happened next?
Well, I was still driving, and I didn't know if the police had caught the van, or if the van would just pop up behind me and maybe even catch up. And I hoped the police were near, but I wasn't going to risk my life on that possibility. So I attempted to call my security and tell them about what was happening.
And why did you attempt to call your security instead of 911?
Because again, I was driving, I could hear the police, but it hadn't seemed like they'd done anything, and I still didn't know if they'd caught the van, and so security was one more hope that I had to stay alive that night.
And what actions did you take to attempt to call your security?
I reached down to grab my phone, but my car started to drift. And so I turned my wheel to correct myself and hit the brakes, but then my car started to skid, and the back end hit some of the construction on the sidewalk.
And then what happened next?
It all happened so fast, but the last thing I remember was a loud crash into my car, and then I was out.
Now, after that crash, what's the next thing that you remember?
I remember waking up in a hospital room and finding out that my sedan had been destroyed by a pile of bricks, but that wasn't all. I found out that someone had died that night because of the chase. Someone had died because that van decided to chase me throughout the streets of downtown.
Now, Dr. Kane, after that chase, were you charged with anything?
Yes, a misdemeanor for reckless driving.
Were you driving recklessly that night?
I was because I had to.
And why did you have to, Dr. Kane?
Why? Because I was driving for my life. I mean, that night I thought it was a real possibility that I would never get to see my wife and kids again, that I wouldn't even meet my son Credit. That was a possibility that I would not accept, and so I did absolutely everything in my power to get away.
Thank you. Your Honor, permission to retrieve Exhibit 1 from the witness stand and pass the witness?
You may.
Thank you.
All right, cross-examination?
Yes, Your Honor, may I proceed?
You may.
Good evening, Dr. Kane.
Good evening.
Now, I'd like to begin by talking about the things you claim you were doing only because you believed you were being chased. Now, you claim you only reached for your phone on Box Avenue because you believed you were being chased, but you were on your phone in your car before you ever saw the van behind you.
For a brief moment while I was stopped, yes.
And you claim you were only driving as fast as you were because you believed you were being chased, but before you ever saw the van behind you, you were driving 15 miles an hour over the speed limit.
I was speeding for a little bit, but that was very different than the way I was driving because of the van chasing me.
Mr. Kane, that wasn't my question. I'm asking whether or not, before you saw the van, if you were speeding 15 miles an hour over the speed limit. And you were.
For a brief period, yes.
And when you did see the van, it cut you off, correct?
Yes, it did.
And somebody jumped out and ran at your car.
Yes, they started approaching my car.
And you saw that that person was holding a gun.
A gun and zip ties, yes.
And you're sure that that person was holding a gun.
That is what I saw.
So, if anyone testified that that person wasn't holding a gun, it's your opinion that they would be lying.
I only know what I saw, so I can't say what other people did.
Well, if somebody said that they weren't holding a gun, you think that person would be wrong, of course, right?
I would think if Bonnie Barrow said that, they would be wrong, yes.
Well, what about if Jess Newton said that, another witness for the prosecution, would he be wrong?
I didn't see Jess Newton that night. I saw Bonnie Barrow.
Mr. Kane, that wasn't my question. If Jess Newton said anything about not holding a gun, do you think he would be wrong?
I would not know, because that night I saw Bonnie Barrow.
All right, Mr. Kane. Now, as the chase began, you continued to drive recklessly. Isn't that right?
Yes, to escape the van.
That is, you reversed and sped down Abbey Road, correct?
Yes, that's what I did.
But no matter how fast you were driving, the van was still behind you.
Somehow, yes, it kept returning.
So you pulled into an alleyway off of Fox Avenue.
Right, I stayed still and cut my lights.
That's right, you turned off your headlights in this alleyway.
That's true, yes.
But only a few moments later, the van pulled in behind you.
That's right.
So you sped out of the alleyway to try to escape them one last time.
Right, I turned on my headlights and sped out the alleyway. Not for one last time, because I still didn't know how long the van would keep chasing me.
Well, Mr. Kane, did you see the van follow behind you as you left the alleyway?
I did not, no, but I still thought they could catch up to me.
Well, Mr. Kane, did you ever see the van behind you after you left the alleyway?
I did not, no.
So, knowing that the van wasn't at least directly behind you, did you stop speeding as you left the alleyway?
Not as I left the alleyway. The only time I did stop speeding was to reach for my phone for fear of the van, to call my security.
Well, Mr. Kane, if you claim you were trying to put distance between yourself and the van, did you leave the downtown area, which was crowded with pedestrians and traffic?
I didn't think to do so. I'm afraid the van had me panicked.
And eventually you turned onto Fox Avenue, where, as you said, you reached for your phone, knocking onto the floor.
Out of fear of the van, yes.
But instead of stopping your car, you bent down, taking your eyes off of the road. Isn't that right?
For a split second, yes.
But in that split second, you lost control of your van, which is when you crashed into the scaffolding.
I did lose control of my sedan, yes.
Now, Mr. Kane, you've read through every witness statement and exhibit in today's case, isn't that right?
Very briefly, yes.
So you read the helicopter pilot's testimony that your headlights were off when you left the alleyway.
I'm afraid I haven't read quite well enough to be able to recite facts.
Would you like me to refresh your recollection?
If you so wish to do so?
Your Honor, permission to show the witness a copy of Del Boone's statement, which he has read, to refresh his recollection.
Any objection?
Yes, Your Honor. I ask that opposing counsel ask the witness questions within his personal knowledge rather than questions about statements from another witness who will testify later today.
May I respond, Your Honor?
You may.
This is well within his personal knowledge, as he himself has read the statement.
Response, Your Honor?
You may.
As the witness has previously testified, he may have looked over the statement, but he does not have great personal knowledge of all the information in the statements, especially of a witness who again will testify later and can be questioned then.
I'll overrule the objection. You may show the statement to the witness.
Yes, Your Honor. Now, Mr. Dr. Kane, if you could read to yourself silently on page 2, lines 25 through 27.
Okay. Okay, yes, I read it.
So you did read Del Boone's testimony that your headlights were off when you left the alleyway.
That's what I just read, yes.
And you also read the deposition of Detective Wilson, where he said that your headlights were off when you arrived at the crash.
When he arrived at the crash and found my destroyed car, yes.
Well, you also remember that while he saw that your headlights were off, the interior lights were working fine.
I believe they did say that, yes.
And finally, you read the testimony of Miss Nothing, where she says that your headlights were off when you crashed into the scaffolding.
Again, I haven't read the statement so closely as to be able to remember all the facts.
I'm happy to refresh your recollection. Your Honor, may I approach?
You may.
Now, if you could read silently from page 3, lines 5 through 6.
Wait. No. Yes. Right?
So, you did read the testimony of Miss Nothing, where she says that your headlights were off when you crashed into the scaffolding.
I've just now read this, yes.
But today, for the first time, you're testifying that you turned your headlights back on after leaving the alleyway, isn't that right?
That is true, yes.
So just to be clear, Dr. Kane, You're testifying for the first time today that you turned your headlights back on after reading the statements of 3 other witnesses who say the opposite.
Yes, because I thought it went without saying, but I do realize now that I have to say it.
Thank you, Dr. Kane. No further questions, Your Honor. I pass the witness.
Redirect.
Yes, Your Honor. Now, opposing counsel just read a portion, or mentioned, a portion of the detective's deposition. Have you read that deposition, Dr. Kane?
I have, yes.
And what did the deposition say about the state of your car when the detective arrived on the scene?
Well, it says that my car was completely totaled. I mean, 3 brick pallets had fallen on it, completely crushing it.
Now, I want to also talk about when opposing counsel asked you about the last time you saw the van. The last time you saw it, was the van still moving behind you?
Yes, it was still coming towards me.
Now, finally, Dr. Kane, they asked about choices that you made that night. What was your state of mind like throughout the entirety of that chase?
It was, as I said, a complete panic. And all I could think about was the next second how to escape the van and how to just stay alive.
Thank you. Your Honor, we pass the witness.
Any recross?
No recross, Your Honor.
All right, thank you. The witness may stand down. Call your next witness.
Yes, Your Honor, the prosecution calls Del Boone to the stand. May I proceed?
You may.
Good afternoon. Please introduce yourself to the court.
Good afternoon, ladies and gentlemen. My name is Del Boone, and I serve as a helicopter pilot, or a roadhead as my fellow soldiers used to call me, with the Texoma Bureau of Investigation.
And Miss Boone, how are you related to the case at hand?
Well, I was the pilot observing the car chase that night, ma'am.
And where did you get your education from?
I received my bachelor's degree in aerospace engineering at the United States Naval Academy, Go-Go's. And then I completed a flight training at the Naval Aviation Schools Command in Florida.
Now, during this time, did you obtain any certifications?
Yes, ma'am. I'm certified to pilot rotary wing aircraft, or the Huey as I like to call them. I've obtained over 2,000 hours of required flight time for my credentials.
Now, after leaving the Navy, where did you go next?
After being honorably discharged by the Navy, I was hired at the TBI, Texoma Bureau of Investigation, to pilot their surveillance aircrafts.
Now, would you say you have expertise in conducting those surveillance flights for the TBI?
Yes, ma'am. I'm more than qualified to conduct surveillance flights. If you include my time piloting for the Navy and the TBI, that'll mark 12 years of being a helicopter pilot. Part of my job at TBI is to monitor Riverside Highway, and I've practically monitored more cars than I can count.
Now I'd like to talk about the night of the car chase. Could you describe how that night started?
I was on shift completing a standard pre-takeoff checklist.
And what was the purpose of that standard checklist?
It's just to ensure that everything on the helicopter readings, such as the speed, are accurate. But unfortunately, our video equipment malfunctioned that night, despite me checking it prior to takeoff.
And what time was this, Miss Boone?
This was at 20:03 hours, ma'am, or 8:03 p.m. This is also when I got the call from the dispatcher requesting aerial support.
And what did you do after receiving that dispatch?
Well, since I was almost done with the checklist, it only took me 3 or 4 minutes to get my bird to the area. And as I was on my way to the scene, a TBI dispatcher was updating me on the situation at hand.
Your Honor, may I approach the witness with what has been marked as Exhibit 3 and pre-admitted as Exhibit 1?
You may.
Ted reads exhibits to opposing counsel. Now, Miss Boone, what is this exhibit?
This is the TBI dispatch communications log.
And was this made at or near the time of the car chase on March 12th?
Yes, ma'am.
And are these statements in this log accurate of your observations of the car chase that night?
Yes, ma'am.
Your Honor, as the times and transcriptions of the log have been stipulated as accurate pursuant to stipulation 16, we move to admit Exhibit 3 into evidence.
No objections.
All right, Exhibit 3 is admitted.
And may the witness step down for demonstrative purposes?
Yes.
Your Honor, may I reposition myself?
You may.
Now, Miss Boone, what did you notice about the area of the car chase?
Well, this here is a map of downtown Texoma. As you can see here, the buildings and the streets are really close together, so if you take into consideration that it was a Saturday night in downtown Texoma, that means that it was really crowded.
And when you got to the scene, what did you see?
Well, at 2012 hours, 8:12 p.m., I observed the black sports car sedan being chased by a white van. I saw them drive north on Main Street, make some crazy U-turn, and then fly southbound.
Now, how fast did you clock those two cars driving at?
Well, here in the Holmes log, I reported that I clocked the sedan at 81 miles per hour and the van at 62.
And how would you describe the driving of both cars?
I mean, they were both driving very erratically. They were swerving through the streets, taking crazy U-turns on busy roads, and even blasting through red lights. It could really only be described as reckless.
Now, what did you see later that night?
But later that night, I saw these police cruisers or ground units approaching from the north side of town.
And what direction were these cruisers going?
They were driving towards the alleyway.
Now, did these police cruisers have their flashing lights on?
Yes, ma'am.
And did you do anything to help these police cruisers?
Of course, at 20 hours, 12 minutes, and 50 seconds, I alerted the dispatch that I activated my spotlight to better assist the ground units in finding the suspect.
Now, after you turned on your spotlight, what did you see, Miss Boone?
Well, I saw the two cars turn down into this alleyway between Larkin and Main Street.
Now, could you see inside that alleyway?
Unfortunately, I could not. There's some tall buildings surrounding the alley, so I can't see inside, but I can still see the perimeter and all the surrounding streets.
So, what did you do next?
I calculated that they were going to come out of the south side of the alley, so I repositioned my bird in that direction. Exactly a minute and 47 seconds later, I saw the sedan exit the alley and head west on Deborah Drive.
Now, when the sedan exited the alley, can you be sure that the sedan had its headlights off?
I was pretty uncertain about it.
Now, did you see the sedan after it went west on Deborah Drive?
No, ma'am. The dispatcher asked me to focus my attention on finding the van, so that's what I did.
And where did you go to search for that white van?
Well, I began scanning the area south of Deborah Drive, and I was told in by dispatch for support over Fox and Main.
Now, while you were making your way to Fox and Main, how was your visibility?
Well, at first things were fine, but as I began approaching the intersection, I noticed some dust and debris was coming from the corner of Fox and Washburn.
And what was the dust and debris that you saw?
Well, I looked over and I saw this collapsed scaffolding. I later learned that the sedan had crashed into the scaffolding and a woman had been killed as a result of the chase.
Now, did you continue searching for the white van?
Of course. I searched from Fox to Connors and from Washburn down the Westway before I was cleared by my supervisor to return back to base.
Thank you, Ms. Boone. You may take a seat. Now, I'd like to talk about the events of the next day. Could you describe how it started?
I was scheduled for a shift at noon. I showed up 20 minutes early because, as they do say in the Navy, the early bird gets the worm. And then I was asked by my boss to retrieve evidence from the evidence room.
What happened in the evidence room, Miss Boone?
Well, I walked in and I realized that I still had my cup of coffee in hand. As I was attempting to open the door, hold the evidence, and grab my coffee, I did accidentally spill my coffee into the bin with the defendant's belongings, which included her me phone.
Was this an accident, Miss Boone?
Yes, ma'am, of course. I would never do it intentionally.
Now, I'd like to talk about your observations of Von Barrow's van the night of March 12th. Did you ever see the van leave the alley?
No. So after the van entered the alley at 8:14, I was watching the alley and the perimeter the whole time. I never saw it leave.
How would you describe the area of Fox and Main during the time of the crash?
Well, the TBI was still in hot pursuit of the suspect, so I saw lots of police cruisers, fire, EMS, and they all had their sirens and lights on.
Now, how distance-wise, how far would you say the alleyway is from the scene of the crash?
Well, it's just a street over, so since I never saw the van leave, it would not have been far from all the commotion.
Thank you, Your Honor. Pass the witness.
Cross-examination.
May I proceed, Your Honor?
You may.
Good evening, Ms. Boone. So as you just testified, you were in the Navy for 11 years, right?
Yes, ma'am.
So you know how to follow rules.
Of course.
And there are rules in your current job.
Yes, ma'am.
One of these rules is that you never bring food or drink into the evidence room.
Yes, ma'am, that is protocol.
But in direct violation of these rules, one day you did bring a cup of coffee with you.
Yes, ma'am, it was merely an accident.
So, of course, when you realized you had your coffee with you, of course you brought it out.
I'm sorry, could you repeat the question?
When you realized you had your coffee with you, when you realized your mistake, you immediately brought your coffee out of the room.
No, ma'am, I put it by a table next to the door, far away from all the other evidence that was stored safely.
But the coffee wasn't far away from the evidence, was it?
It was far away from the evidence stored safely, but there were still some unmarked bins that were next to the table.
But that's still not far away from the evidence, because when you picked up the evidence you were getting, you spilled your coffee on the defendant's phone.
Yes, ma'am.
So of course, when you realized your mistake, you immediately took the phone out of the coffee, right?
No, ma'am, I did not.
Instead, you left the room for a minute.
Yes, ma'am, I went to go grab paper towels in an attempt to fix this mistake.
So by the time you had returned, so much coffee had spilled on the phone that no data was able to be pulled from it.
Yes, ma'am, that's correct.
And you're aware that evidence on this phone potentially could prove the defendant's innocence.
I'm not sure.
Your Honor. Lack of personal knowledge as to the contents of the phone. Ms. Boone does not know what was on the phone and therefore cannot testify as to whether it would help the defense or not.
Response?
Ms. Boone is aware she found out later what was on the phone that the defendant claims would have proved her innocence.
I'll sustain the objection.
Now, Ms. Boone, you were here when Jess Newton testified, right?
Yes, ma'am.
And Jess Newton is also testifying for the government.
Yes, ma'am, the prosecution.
So you heard Jess Newton testify that the van left the alley immediately after what he thought was the crash.
After hearing law enforcement in the crash, yes, ma'am.
But it's your testimony that the van must have left over 11 minutes after the crash.
I'm not sure when the van left, to be honest, because I never saw it leave.
Right, and even though you didn't see it, you were searching all of downtown, right?
Of course, I had to find this dangerous person.
But you never saw the van, did you?
I never saw it leave, that's correct.
So it's safe to assume that you think the van left after you left the area.
I'm not certain when the van left, ma'am.
Now I'd like to talk about your very first car chase. You saw the sedan leave the alley at 8:14 p.m.
Yes, ma'am, that's correct.
And then a few minutes later at 8:17, you saw some dust and debris blow up in the air.
Yes, ma'am, on Fox and Washburn.
But you never saw the woman, Miss T. Dealey, die, did you?
No, ma'am, I didn't. I later learned that it's part of my job at the TBI.
So you don't know how long after the scaffolding crashed that Miss T. Dealey died?
No, ma'am, I do not have that information.
You're aware that one of the elements the government has to prove today is that the victim died after the van left the alley.
Sure.
But you don't know what time the victim died.
I do not, ma'am. I only know that the scaffolding crashed at 8:17.
Let's talk about what else you don't know. You don't know when the van left the alley.
That's correct.
And as a matter of fact, after the sedan left the alley, you never saw the van again.
Yes, ma'am.
So you never saw the van chasing the sedan ever again?
After the sedan exited the alley, I did not. That's correct.
Right, so at this point, it would be safe to assume that the chase was over.
I'm not sure.
Objection, Your Honor, speculation. The witness is asking the attorney is asking my witness to make assumptions as to when the chase ended.
Response?
Your Honor, Miss Boone was watching the chase from the sky, and she saw the vehicles chasing each other around prior to the alley. She never saw the van chasing the sedan ever again, and so I'm asking about her rationally based perception of what she witnessed that night.
Overall.
Let me re-ask my question. So it's safe to assume that after the sedan left the alley, the chase was over?
I'm not sure. I was not in either of the cars, so I really don't know.
But just to be clear, you never saw the van chasing the sedan, right?
After the sedan exited the alley, yes, ma'am.
Now, you also can't be sure whether the van did not leave the alley before the crash.
I'm most certain that it didn't, but I cannot be 100% sure.
So there is a possibility that you missed the van leaving the alley before the crash.
Small possibility.
Thank you. No further questions, Your Honor. I pass the witness.
Redirect.
Yes, Your Honor. Miss Boone, what was your reasoning for putting the coffee by the door?
Well, as I mentioned earlier, most of our evidence is stored far and safe away from the door. I merely set it next to the table to avoid from contaminating any of the evidence that was stored safely.
Now, after the unfortunate spill, did you try to clean up the mess?
Of course I did. I mean, I was panicked, and so I went to go grab paper towels, and I attempted to fix my mistake.
And did you try to keep the evidence from being affected by the coffee?
Yes, ma'am, of course.
And was this an honest mistake on your part?
Like I said, I would never do it intentionally.
Now, you said that you never saw the van again you said you never saw the van again that night.
Objection leading.
I can rephrase, Your Honor.
Rephrase.
Now, did you ever see the van after it entered the alley?
No, ma'am, I did not.
And did you search for this van?
I searched far and wide, and I never saw it.
Thank you, Your Honor. I pass the witness.
Recross.
No recross, Your Honor.
All right. The witness may step down. Does the state rest its case?
Yes, Your Honor, the state rests.
All right. Defense, call your first witness.
The defense calls Bond Barrow to the stand. May I proceed?
You may.
Good evening, Miss Barrow. Could you introduce yourself to the jury?
Hello, my name is Bond Barrow.
And could you tell the jury why you're here today?
I'm here because I've been charged with attempted kidnapping and murder.
Now, before we get into that, Miss Barrow, could you tell the jury a little bit about yourself?
Well, I'm from right here in Texoma City. I even went to high school just a couple miles down the road.
And what did you do after high school?
After high school, I felt a strong duty to serve my country, so I joined the Marines, where I served for 4 years, including a year in Afghanistan. Then I started working for the Texoma Rangers for 4 years, and then I began working for the company Rexford Solutions.
Now, Miss Barrow, how did you come to be charged with attempted kidnapping and felony murder?
I guess it all started when I learned about that businessman, Kenton Kane.
How did you learn about Kenton Kane?
I read an article in the Texoma Journal about how he had apparently been selling weapons to some country in Europe, and they had been using those weapons.
Your Honor, hearsay. Opposing counsel has not admitted this article into evidence, and this is a direct statement.
May I respond, Your Honor?
You may.
We are not offering these statements for the truth of the matter asserted, that Mr. Kane is in fact an arms dealer, rather the effect that they had on Miss Barrow, that she believed these statements and acted in concordance with them, that she began to stake out Mr. Kane's property.
Response, Your Honor?
You may.
If that is the case, then we would like to lodge an objection to relevance under Rule 403, more prejudicial than probative. This evidence is more prejudicial against Kenton Kane's character than it is to prove any kind of subsequent actions of Miss Barrow.
Response?
Yes, Your Honor. As this testimony goes on, Miss Barrow will testify that the reason she abandoned the chase is because she didn't want anyone to get hurt. She will also say that that's the same reason that she started the chase in the first place, because she believed that Mr. Kane was unduly harming people.
Response, Your Honor?
You may.
This evidence in this article makes unsubstantiated claims about Kenton Kane that nobody is able to prove in court today, which effectively hurts his character and prejudices him against the jury rather than proving subsequent actions.
May I respond, Your Honor?
You may.
This testimony and Miss Barrow's own motive for the chase prove that she did voluntarily abandon the chase, and that she did have a real change of heart, as her motive was always to help people from not being hurt, which is because she learned these things about Mr. Kane.
I'll overrule your objections.
Now, Miss Barrow, if you could continue to tell the jury the things you were learning about Mr. Kane.
Well, I was learning that as he was selling these weapons to this country, they were using these weapons to hurt and kill innocent people. And I also learned that even though he lives in Texoma City, the government wasn't doing anything to stop him.
What did you do after learning these things about Mr. Kane?
Well, I realized that if no one was going to stop him, then I guess I would have to find a way to stop what he was doing.
How did you plan on stopping Mr. Kane?
I didn't exactly know at the time, so I just started staking out his house, doing surveillance on the property.
What happened when you began to stake out Mr. Kane's property?
Well, a couple days in, I invited my friend, or he used to be my friend, Jess Newton, to join me.
What happened when Mr. Newton joined you?
He got really intense about the whole thing. He started suggesting that we use rifles against Mr. Kane and even that we use bombs against him. He was wanting to murder Mr. Kane.
Objection, Your Honor. Hearsay as to the statements made by Jess Newton.
May I respond?
Response?
Your Honor, these statements fall under hearsay exception Rule 8033, present mental condition, which provides that statements which establish a declarant's present mental condition, including a motive, intent, or plan, are admissible. As these statements were directly establishing Mr. Newton's intentions and plans for the stakeout, they are admissible under Rule 8033.
Response, Your Honor.
You may.
Opposing counsel has laid no foundation to prove that this would prove a mental intent of a witness, and they have laid no foundation to prove that this would show Jess Newton's mental state at this point.
May I respond, Your Honor?
Your objection's overruled.
Ms. Barrow, if you could continue to tell the jury the things that Mr. Newton was suggesting.
Well, he was wanting to assassinate Mr. Kane, and he told me all the ways that he wanted to do it.
How did you react to Mr. Newton's suggestion that you should assassinate Mr. Kane?
Well, I knew that, of course, we shouldn't do that, because if we were to kill Mr. Kane, then we would be no better than he was. So I convinced Jess not to kill him, and I said that we should just do a citizen's arrest instead. Just detain him and turn him over to the police.
Were you able to perform a citizen's arrest?
Well, on March 12th of that week, we saw Mr. Kane drive away from his property with no bodyguard, and we started following him.
Where did you follow Mr. Kane?
We followed him to downtown Texoma City, and that's when I swerved the van in front of his car.
What happened when you swerved in front of Mr. Kane?
That's when Jess got out of the van. He was holding his gun and zip ties to detain Mr. Kane.
What happened when Mr. Newton ran out of the van at Mr. Kane?
Well, that's when Mr. Kane started pulling all these crazy driving maneuvers. He, reversed away really fast and spun his car around and then started driving down another street. It was honestly the craziest driving I've ever seen in real life.
What did you do after Mr. Kane reversed and sped down the downtown street?
Well, me and Jess just tried our best to keep following him.
And in the course of following Mr. Kane, did you ever hear police sirens?
I did. Partway through the chase, I heard police sirens, and that actually made me relieved because that meant that the police would be there when we caught Mr. Kane, so we could just turn him over right then.
Were you able to turn Mr. Kane over to the police?
No, because eventually he turned into an alley, and I guess turned off his headlights because we couldn't see where he'd gone to after that.
What did you do when you realized you had lost Mr. Kane?
I just stopped the van in that alley, and I got to thinking about how the whole chase had gotten a lot crazier than I was expecting. I mean, I hadn't expected Mr. Kane to be able to drive as crazy as he did and make all those maneuvers. And I started thinking that this chase was getting too dangerous. I mean, the only reason I started it in the first place was because I wanted to stop people from being hurt. And I definitely did not want anyone to get hurt in the car chase. So once I realized it was dangerous, I left. And I left the situation to the police.
Miss Barrow, do you know what time you left the alleyway and decided to go home?
Yes, I know it was exactly 8:15 when I left because I checked my phone and I pulled up Google Maps on my phone and I saw it was exactly 8:15.
Do you have your phone today in court to show the jury the data it would have recorded?
No. My phone was taken for evidence, and the police spilled so much coffee on my phone that it was completely destroyed, and no evidence could be gotten out of it.
And going back to when you did leave the alleyway, did you try to avoid the police on your way home?
Of course not. I mean, I thought that the police wanted to catch Mr. Kane, so I just drove home.
And, Miss Barrow, when you first planned your citizen's arrest, did you expect that over 6,000 pounds of bricks would be illegally left on a scaffolding unit overnight?
Of course not. I mean, no one could have expected that.
And when you first planned your citizen's arrest, did you expect that a pedestrian would wander into a closed-off construction site?
Of course I did not expect that.
And when you finally abandoned your attempt, did you expect that Mr. Kane would continue to drive recklessly?
Of course not. I hadn't even expected him to start driving the way he was in the first place, and I left the chase to stop it from getting dangerous.
Thank you, Miss Barrow. No further questions, Your Honor. I pass the witness.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Ms. Barrow. Today I'll be asking you some questions about your testimony, and I'd like to start off with your plan for Kenton Kane. You had a plan to turn Kenton Kane over to the police, correct?
That's right, ma'am.
And this was through an illegal citizen's arrest, right?
I did not know it was illegal at the time, but now I know that.
Well, Ms. Barrow, regardless of whether you knew it was illegal at the time of the chase, it was still illegal when you committed it, wasn't it?
Yes, ma'am.
And Ms. Barrow, you said in your own words that once Mr. Kane left his house, you had the perfect opportunity, correct?
Yes, ma'am.
In your own words, the perfect opportunity to snatch Kenton Kane, correct?
That's right, ma'am.
And this was all in an attempt to apprehend Kenton Kane, correct?
Yes, we were trying to detain him to turn him over to the police.
And this would be against his will, wouldn't it?
I didn't expect him to come willingly, no ma'am.
So is that a yes to my question? It was against his will?
Yes, ma'am.
And Ms. Barrow, I'd like to clarify, you only have 2 weeks in evasive driving training, correct?
Yes, through Rexford Solutions.
And you've even admitted that this driving isn't as extensive as the professional drivers receive, correct?
No, they receive more training.
And Ms. Barrow, you've never even been involved in a car chase before, have you?
I have not.
Let alone a high-speed car chase.
No car chases.
In a crowded downtown area.
This was in a crowded downtown area.
Yes, but you've never committed a high-speed car chase in a crowded downtown area other than this one, correct?
No, ma'am.
Now, Ms. Barrow, even though you have no experiences in car chases, you decided to swerve in front of Kenton Kane's car, hemming it to the curb, correct?
Yes, I did.
And at this point, your intention was that Kenton Kane would not be able to move his car, correct?
Yes, ma'am.
Now, at the same time that this happened, your accomplice, as you claim, got out of the car with zip ties and a firearm, correct?
Yes, that was Jess Newton.
And as you claim, Jess Newton approached that vehicle with the zip ties and the firearm, correct?
Yes.
Now, I'd like to clarify, this is when you still had Kenton Kane pinned to the curb so he couldn't move, right?
The van had not moved away at that point, no.
Is that a yes to my question?
Yes.
Now, Ms. Barrow, that would mean that at the same time Kenton Kane was being approached with a firearm and zip ties, you still had the van pinned to the curb so he couldn't move.
Yes, ma'am.
But he still got away from you, didn't he?
Yes, he pulled a really crazy maneuver.
Right, but you continued to persist on with this chase regardless of that, didn't you?
Yes, ma'am.
Your Honor, pursuant to Stipulation 18, I would like to read page 6, lines 14 through 16 of Exhibit 5, which is Detective Lars Wilson's deposition.
You may.
Ms. Barrow, I'm reading to you Detective Lars Wilson's description of your actions on the night of March 12, 2022. I interrogated Newton for approximately 45 minutes and learned that Newton and another individual, Bonnie Barrow, had attempted to kidnap Kenton Kane in some altruistic effort of a citizen's arrest. Now, Miss Barrow, Detective Lars Wilson actually described your actions as attempting to kidnap Kenton Kane, correct?
That's what he said.
That's a yes?
Yes.
And Miss Barrow, going back to your plan, you planned on snatching Kenton Kane,
Yes.
turning him over to the police
That's right.
against his will, right?
Yes, ma'am.
And finally, Miss Barrow, I'd like to talk about all the times that you stopped during this chase. Now, you claim to have heard police sirens just before entering an alleyway, correct?
It was actually a couple minutes before.
But you still heard those police sirens before you entered the alleyway, correct?
That's right.
And you stopped this chase later on in that alleyway, right?
Yes.
Your Honor, permission to approach the witness with what has been pre-admitted as Exhibit 1.
You may.
Ms. Barrow, this is an accurate depiction of downtown Texoma, correct?
Looks like it.
Now, Ms. Barrow, I'd like you to follow along with me. You stopped this chase in this alley right here, correct?
Yes, ma'am.
Now, I'd like to talk about all the other times you would stop during this chase. You stopped down here at the light at Larkin and Westway, which was a red light, correct?
Yes, because it was a red light. Yes.
But, Ms. Barrow, to clarify, you didn't stop following Kenton Kane at this point, right?
Not at that point, no.
Even though you had stopped, right?
Right, it was a red light.
Now, Ms. Barrow, you also stopped right up here at Beta Road, in which you hemmed Kenton Kane's car to the curb.
Yes.
But to clarify once again, you didn't stop the chase when you were stopped here, did you?
No, that's because Jess was getting out of the van at that point.
And Kenton Kane was being approached and trapped with a firearm, correct?
Yes,
Now, Ms. Barrow, you say you stopped the chase in this alley right here,
I did.
which is subsequently after you heard law enforcement, isn't it?
Yes, that was a couple minutes after I noticed that.
After you heard the police sirens,
Yes.
after you acknowledged a possible police helicopter above you.
I didn't know whether or not it was a police helicopter.
Well, you did concede that it was either a police helicopter or a news helicopter, didn't you?
Yes.
And that was after you saw this helicopter searchlight focused on you, right?
Yes, I noticed the helicopter and the siren a little while before that.
Now, Miss Barrow, to clarify, once you heard law enforcement, you didn't make any efforts to go find that law enforcement, did you?
No,
You didn't pull out your Me Phone and make a call to the police letting them know where you were, right?
I didn't talk and drive, ma'am.
Is that a yes to my question? You didn't make a call to the police with your Me Phone?
Yes.
At this point, you didn't go search out the police to let them know that Kenton Kane was right at the end of that alleyway.
No, I figured they already knew.
But you didn't know if they knew, did you?
I guess I didn't know.
Now, Miss Barrow, you didn't stay after the chase and help the police identify somebody that you considered to be dangerous, did you?
No, I left and I went home.
You left and you went home. You left that alleyway, right?
Yes.
Which is only after you heard law enforcement.
Yes, that was a few minutes after.
Your Honor, we pass the witness.
Redirect.
Brief redirect, Your Honor. Ms. Barrow, did you abandon your attempt directly after hearing or seeing any sort of law enforcement?
No, I noticed the law enforcement a few minutes before during the chase. It was later in the alley after I noticed it was dangerous. That's when I left.
Thank you, Ms. Barrow. No further questions, Your Honor. I pass the witness.
Recross.
Yes, Your Honor. Miss Barrow, to clarify once again for the jury, you did not leave that alleyway until after, well, you heard law enforcement before you left that alleyway, didn't you?
I did.
Regardless of the multiple times you had stopped before,
Yes?
in which you didn't hear law enforcement.
No?
Your Honor, we pass the witness.
All right. The witness may step down.
Your Honor, the
next
defense
witness.
calls Jill O'Nothan to the stand. May I proceed, Your Honor?
You may.
Good evening, Miss O'Nothan. Could you please introduce yourself to the jury?
Hey y'all, my name is GTO, or I guess more officially it would be Jill O'Nothan.
And could you tell the jury a little bit more about yourself?
I'm 28 and I'm a proud, lifelong resident of Texoma City.
How are you related to today's case?
Well, I was with my best friend, TD, or T. Dealey, when she was killed by Kenton Kane.
How long had you known Miss Dealey?
I've known her since middle school. I mean, we've been best friends ever since. Once we got out of high school, we started going out to eat together every week to catch up, and that's where we were the night of her death. We were at our favorite restaurant, Tex-Mex Thai,
And where was this restaurant located?
in downtown Texoma City.
Now, I'd like to talk to you about the area surrounding the restaurant. Could you tell the jury about the construction around the corner?
Yes, there was this construction site around the corner from the restaurant, and it looked like they were re-bricking the side of the building.
Would you recognize images of this construction if I were to show them to you?
I would, yes.
Your Honor, may I approach the witness with what has been previously marked as Exhibits 2 and 9?
You may.
Let the record reflect that I am showing Exhibits 2 and 9 to opposing counsel, Ms. Monicondon.
The record so reflects.
Ms. O'Noughen, what are each of these exhibits?
Exhibit 2 is a picture of bricks, and Exhibit 9 is a picture of some scaffolding.
Now, are these the exact bricks and scaffolding that were in the construction site that night?
They are not, no.
Do they appear to be fair and accurate models of the bricks and scaffolding that would have been there?
They do, yes.
Do they appear to be changed or altered in any way?
No, they do not.
Your Honor, I now move to admit Exhibits 2 and 9 into evidence.
Any objection?
No objections, Your Honor.
Exhibits 2 and 9 are admitted.
May I publish copies to the jury?
You may.
Now, Ms. O'Noughen, could you tell the jury more about the construction going on?
Yes, in the construction site, there were 5 of these scaffolding units in a line, and then there were some of these brick pallets on top of that scaffolding.
And was this construction site easily accessible to people like you?
Well, no, it wasn't. There were these huge barricades closing off the construction site, and it didn't seem possible to me that anyone could have gotten in.
Now, I'd like to turn your attention to your dinner that night. How did the evening go?
Well, it went pretty well at first. We ordered what we always got. She got her fajitas, and I got my pad thai tacos. And then she ordered some more drinks, so I went outside to smoke.
Did you see anything when you went outside to smoke?
Well, yes, actually. I saw a helicopter overhead, and I also heard some distant car tire screeches. And I heard a distant police sirens. And then I saw this black sedan followed by a white van make this crazy U-turn around the restaurant.
Was Miss Dealey with you when you witnessed this part of the car chase?
No, she wasn't. But our favorite movie is, or I guess it was, Fast and Furious 4. So I wanted her to come and see what was happening.
So did you go to get Miss Dealey?
I did, yes.
And what happened when you went to go get Miss Dealey?
Well, before I went inside, she came stumbling out of the restaurant looking kind of drunk, which I thought was a little weird because she hadn't had enough time to get drunk. But then I noticed that she didn't have her leather jacket with her. That leather jacket was her favorite jacket, and she never left it anywhere. So I told her I would go inside and grab it for her.
Did you go back inside and grab it for her?
I did, yes.
And what happened when you came back outside?
Well, I came back outside, but TD had disappeared.
What did you see when you returned outside?
When I came back outside, I saw a white van turning out of an alley and it turned west onto Deborah Drive out of the downtown Texoma City area.
So, did you ever go to look for your friend?
I did, yes. After I saw that white van, I ran across the overhead walkway on Main Street, and then I turned right on Fox Avenue to continue searching for TD.
And when you arrived on Fox Avenue, what did you see?
Well, as I was running along Fox Avenue, I ran into the construction site, and I realized I couldn't get around the barricades, so I was going to turn around and cross Fox Avenue to the north side of it, so I could keep searching for TD.
Did you cross Fox Avenue?
Well, before I could, this black sedan came hurtling by at 100 miles per hour.
Objection, Your Honor. Lack of personal knowledge as to the speed of the sedan. This witness has no way to know the real speed of the sedan.
Response?
Your Honor, the witness is merely testifying as to her rationally based perception of the event she witnessed.
Response, Your Honor.
I'll sustain the objection.
So, Miss O'Noughin, what happened when you saw the black sedan?
Well, it came speeding by and almost ran into me and almost killed me. And it didn't have its headlights on, so I couldn't see it and it couldn't see me.
What did the sedan do next?
Well, instead of running into me, it ran into this scaffolding in the construction site, which then started all of the scaffolding falling into each other, and the brick pallets all fell off, and there was so much debris flying everywhere that I had to duck under a nearby building so I would not get hit.
Miss O'Noughin, did you ever find your friend?
I did, yes. After the debris had cleared, I ran out from under the building, and I was searching along Fox Avenue, looking on both sides, hoping that TD wasn't caught in any of the debris, but I found her lying past the scaffolding with one of those huge brick pallets crushing her.
And then what happened?
Well, I ran over to her, desperately calling for help, but I was too late. She died in my arms.
Miss O'Noughin, did you expect to find your friend laying in a construction site, buried in bricks?
No, I didn't. It didn't seem possible to get into that construction site.
I'd like to go back to something you said earlier. When exactly did you see the white van leaving the downtown area?
I saw it right before I saw the black sedan run into the scaffolding.
And how can you be so sure of this?
Because I know for a fact that I saw that white van turn out of the alley before I watched my best friend die.
Thank you. No further questions, Your Honor. I pass the witness.
Cross-examination?
Yes, Your Honor. Miss O'Noughin, I'm incredibly sorry for your loss, but I have a few questions about what you saw that night, as well as what you didn't see. You saw the black sedan on the merge, right?
Yes, I did.
And this was when you were on the patio, correct?
Yes, on the patio of the restaurant.
Now, this was sometime between 8 o'clock and 8:15 p.m., right?
That is correct.
Now, from the patio, you could see the helicopter spotlight sweeping the area, right?
I could, yes.
And you also heard police sirens, didn't you?
Yes, I did.
And then you saw the sedan being chased by the white van, correct?
I did, yes.
So just to clarify, you saw the sedan being chased by the white van after seeing the helicopter spotlight, correct?
Yes.
You saw the van chasing the sedan after you heard sirens, correct?
Yes, that is correct.
So then you went into TMT to get TD's jacket, right?
Yes, I did.
Well, after coming out of TMT, you noted that these sirens were louder than before, right?
I did, yes.
Now, typically, louder sirens means that these police crews are getting closer to you, right?
It does, yes.
Now, after leaving TMT, this is also when you saw the van leave Deborah Drive, right?
Could you repeat your question?
When you heard the sirens get louder, you also saw the van leave Deborah Drive, right? Or sorry, leave the alley and turn onto Deborah Drive, correct?
A little bit after that, but yes.
So this would mean that you saw the van leave the alley as these police cruisers were getting closer to you, right?
I guess.
Now, next, I'd like to talk about. Now, the first time you saw the van, it was chasing the sedan on the merge, right?
That is correct, yes.
Now, you didn't know why the van was chasing the sedan, did you?
No, I didn't.
You didn't know why the sedan was speeding away from the van, did you?
I assume it was because it was being chased.
You didn't know why how long the chase had gone on for, did you?
No, I did not.
You didn't know if anyone in those cars were armed, did you?
No, I did not.
You didn't know if anyone in those cars had a gun or zip ties, right?
Yes, that is correct. I did not know that.
All you knew was that a van was chasing a sedan, right?
Yes.
And then several minutes later, the sedan crashed into some scaffolding, right?
Yes, after I saw that white van turn out of the alley.
Now let's talk about the timings of when you saw these cars. You first saw the sedan and van on the merge, right?
I did, yes.
And you saw them travel the distance from the merge onto the turning on Deborah Drive, correct?
That is correct, yes.
Now you testified that these cars were going very fast, right?
They were, yes.
So since they were going so fast, this short distance couldn't have taken very long for them to travel, right?
No.
Now, the next time you saw one of the cars involved in the car chase, it was the white van, correct?
Yes, that is correct.
Now you saw this white van turn out of the alley and onto Deborah Drive, right?
Yes, I did.
And right after you saw this, you were blinded by the helicopter spotlight, correct?
Yes, that is correct.
Now, because you were blinded by the helicopter spotlight, you couldn't see where the van went after it turned onto Deborah, right?
No, I couldn't.
Now, the last time you saw one of the cars involved in the car chase, it was the black sedan on Fox Avenue, correct?
Yes, when I saw it run into the scaffolding that killed my best friend.
Right, but this was a few seconds before the crash, right?
Yes.
Now, every instance that you saw one of the cars involved in the car chase was a brief encounter, wasn't it?
Yes, it was.
And your testimony in court today is based on those few brief encounters, is that right?
Yes, it is.
Now, I'd like to talk about TD's condition when you saw her on the patio. It's your belief that she couldn't have been drunk, right?
Well, she looked pretty drunk.
But it's your testimony that she could not have been drunk, right?
It didn't make sense that she was drunk.
Objection, Your Honor, non-responsive.
Response?
Your Honor, the witness is merely clarifying what she believed about the state of her friend.
Response, Your Honor?
You may.
Any clarification can be done on redirect. My question was a simple yes or no.
I'll overrule the objection.
Now, it's your belief that TD could not have been drunk that night, right?
Well, it didn't make a lot of sense that she was drunk.
Is it your testimony that TD couldn't have been drunk that night?
I'm sorry, I'm confused about what you're asking.
Is it your testimony that on the patio, TD did not seem drunk to you?
No, she did seem drunk.
Right. And so, well, it's actually your testimony that you believe she couldn't have been drunk, right?
It didn't make sense that she was drunk, no.
And this is because you didn't see how much tequila she drank, right?
Well, I know she ordered 2 flights of the tequila tasting flight, yeah.
You didn't know how much of that she drank, right?
I know she drank 1 of the flights.
You didn't know, you didn't believe there was enough time for that second tequila flight to register in her system, right?
Yes, that is correct.
Now, I'd like to talk about why you're testifying here today. You're testifying because you believe that Kenton Kane should be responsible for the death of T. Dealey, right?
She is responsible.
Now, that's why you reached out to Miss Barrow's attorneys, right?
Yes, it is.
Now, before reaching out, you had no idea who Miss Barrow was.
No, I did not.
You didn't know that she was the driver of the white van?
No, I didn't.
And yet you're still testifying on her behalf today, is that correct?
That is correct, yes.
Your Honor, I pass the witness.
Brief redirect, Your Honor.
Yes, you may.
Mr. Nathan, after hearing all the evidence about the car chase, has your opinion on who was responsible for your friend's death changed?
No, it hasn't. I still believe Kenton Kane killed TD.
And why is that?
Because I saw that black sedan run into the scaffolding, which knocked the brick pallets onto my best friend, and that was after I had seen the white van turn out of the alley.
Thank you. No further questions, Your Honor. I pass the witness.
Recross.
Very briefly, Your Honor.
You may.
Mr. Nathan, when you saw the black sedan on Fox Avenue, you didn't see the sedan. You didn't see the van, did you?
I had seen it a little bit before.
Pass the witness, Your Honor.
All right. The witness may step down.
Your Honor, at this time, the defense calls Sam Bass to the stand. May I proceed?
You may.
Good evening, Miss Bass. Could you please introduce yourself to the jury?
Good evening, my name is Sam Bass and I'm a professional engineer.
Could you explain to us your educational background?
Yes, so I went to university in Australia where I graduated valedictorian and then I moved to the US.
And could you explain a little bit of your professional background?
Yes, so I worked for the TBD or the Texoma Buildings Department as a junior inspector for 4 years, and then because I have a special talent in structural analysis and investigation, I was promoted to senior inspector. And then after that, I founded my own company.
Could you tell us about the company that you founded?
Yes, so I founded Base Structural Investigations, and it's an investigation and a consulting firm.
And why are you here today?
I'm here today to provide an engineering perspective on the nature and the foreseeability of the event.
Now, before we go any further, are you being paid for your time here today?
Yes.
Now, when did you first become involved with this case?
So back when I worked for the TBD, I was the first officer on the scene.
And what were your initial observations when you arrived on this scene?
So I noticed that some scaffolding had fallen and it was holding 3 brick cubes, one of which had fallen onto a black sedan, the other unfortunately on a pedestrian, and the other on the ground.
Now, do you have Exhibit 2 and 9 in front of you?
Yes, I do.
And very briefly, did the construction site that you observed have a permit approved by the Texoma Buildings Department?
Yes, I was actually the one to approve that permit.
And when you approved this permit, did you expect that this construction site would follow all Texoma safety laws and regulations?
Yes, it's their job to know all the rules and regulations that they have to follow in order to be safe.
Now, holding up Exhibit 2 for the jury, can you briefly explain what it shows?
Yes, so this is an example of the brick pallets that would have been on the scaffolding.
Now, holding up Exhibit 9, can you show the jury where those brick pallets were before they fell?
Yes, so 3 brick pallets were left on the top row of the scaffolding.
Now, Ms. Kane, was it unusual that these brick pallets were on top of a scaffolding unit at night?
Yes, it's very unusual because construction companies aren't allowed to leave anything on the scaffolding overnight.
So, is it illegal for brick pallets to be left on scaffolding units overnight?
Yes, it's illegal and you will get issued a very large citation.
To you, Ms. Bass, was it foreseeable these brick pallets would be left on top of a scaffolding unit overnight?
No, it's not foreseeable.
Now, I want to talk about the notes that you created. When you arrived at the scene, did you take notes on everything you saw that night?
Yes, I did.
And did these notes aid in your final conclusion?
Yes, they did.
Would you recognize a copy of these notes if I was to show them to you?
Yes, I would.
Your Honor, may I now approach the witness with what has been previously marked as Exhibit 7?
You may.
Let the record reflect I'm showing a copy of Exhibit 7 to opposing counsel, Ms. Silverman. Now, Ms. Bass, do you recognize this?
Yes, I do.
And what is it?
This is a copy of my notes.
Is it a fair and accurate copy?
Yes, it is.
Does it appear to have been changed or altered in any way?
No, it has not been.
And when you created this copy, and did you create this copy at or near the time of observing the crash?
Yes, I did.
And when you created this, are you a custodian of this document?
Yes, I am.
And this was kept in the regular course of business?
Yes.
And when you created this, you were still working for the Texoma Buildings Department?
Yes, I was.
Objection, Your Honor, leading.
I'll sustain the objection. Read
All right.
Grace.
Now, Ms. Bass, when you created this, were you still working for the Texoma Buildings Department?
Yes, I was.
And were you under a legal duty to report when you created this document?
Yes, I was.
And is this document trustworthy?
It is trustworthy.
Your Honor, I now move to admit Exhibit 7 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 7 is admitted.
Your Honor, may the witness step down from the stand to better show Exhibit 7 to the jury?
Yes.
Your Honor, may I reposition myself?
You may.
And may I publish copies of Exhibit 7 to the jury?
Yes, you may.
Here's some copies, stand up. Now, could you briefly explain the drawing that you made on this exhibit?
Yes, so right here, these orange lines are the barricades. Here is a crash scaffolding. This is one of the brick cubes. Here is a sedan with the brick cube on top of it, and here, unfortunately, is the deck.
And were you ever able to determine what had caused the scaffolding to fall?
Yes, so I knew that the scaffolding had fallen because the sedan had hit it.
And what led you to believe this?
So I saw scratch marks on the front right bumper of the sedan, and I also saw black paint transfer on the scaffolding that corresponded with those scratches, so I knew that it was the front right bumper of the sedan which had hit the scaffolding.
And was there anything unusual you noticed about Mr. Kane's car?
Yes, so Mr. Kane's car, the lights were off. The headlights were off, and yet the interior lights were still on.
Now I want to talk about the positioning of the pedestrian on the sidewalk. Can you point to where the pedestrian unfortunately died?
The pedestrian was right here.
And Ms. Bass, was it unusual that a pedestrian was underneath a scaffolding unit?
Yes, it's very unusual.
And why is that?
So you see, she was in between two barricades, which are virtually impossible to cross.
And if these barricades are virtually impossible to cross, how would a pedestrian end up in a scaffolding, underneath a scaffolding unit?
So a pedestrian would either have to walk into a busy street or climb over.
Now, Ms. Bass, to you, was it foreseeable that a pedestrian was underneath a closed-off scaffolding unit?
It's not foreseeable at all.
Your Honor, may the witness return to the stand?
Yes.
Finally, Ms. Bass, what is your expert conclusion as to how the scaffolding fell that night?
So the scaffolding fell holding brick pallets that weren't supposed to be there. And unfortunately, it fell on top of a pedestrian who wasn't supposed to be there.
No further questions, Your Honor. I pass the witness.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good evening, Miss Bass. Now, I want to start off by talking about your investigation. You got a call from the Texoma Building Department to go investigate the scene on March 12th, right?
Yes, I did.
And when you got that call, you weren't told anything about a chase, were you?
No, I was not.
All you were told was that a sedan had hit some scaffolding, right?
Yes.
The scaffolding had collapsed, right?
Yes.
And a stack of bricks had fallen, right?
Yes.
So you had no information about a chase occurring at this point, right?
Not at that point.
But then you visited the scene that night, right?
Yes.
And to be clear, that was the only time you ever visited the scene, right?
Yes.
And while you were on the scene for that one time, you didn't take any photos, did you?
I did not take photos, but I took very reliable notes.
But we have no objective evidence, like photos, from you as the only investigator on the scene, correct?
You have my notes and my conclusion.
But no photos, right?
No, there's no photos.
You also never went back to that scene in the daylight, did you?
No, I did not.
Even though you testified that that night it was unusually dark, right?
Yes.
And you also never went back in the following days to conduct a structural investigation as you almost always would, right?
No, it was not necessary in this case.
So that's a no, you never went back in the following days to conduct a structural investigation?
No, I did not.
But you did make a preliminary notes and sketch while you were on the scene, correct?
Yes, I did.
And because we have that with us today, I'd like to take a look at what you wrote. Your Honor, permission to approach the witness with what has been admitted as Exhibit 7.
You may.
Tendering my copy to opposing counsel. Now, Ms. Bass, you'd say that this is a fair and accurate copy of your sketch, correct?
Yes, it is.
Now, I'd like to take a look at what you wrote. So starting off at line 1, you wrote sedan, no skid marks, correct?
Yes.
Now,
Your Honor, I believe the witness has a copy of Exhibit 7 on the stand, and I'd ask that opposing counsel step away from the witness and just merely hold it up at least a step or two.
response, Your Honor?
I'll overrule the objection.
So,
Proceed.
Ms. Bass, you wrote sedan, no skid marks. Did I read that correctly?
Yes.
But the area where you claim the sedan would have driven, it was covered by scaffolding debris, wasn't it?
Yes.
And you only looked through all this debris from a few feet away, right?
Yes, I was not allowed to mess with the scene.
So you were only a few feet away, right?
Yes.
And this was on a night that you described as unusually dark, correct?
Yes.
Now, I'd also like to take a look at the timing of all of this. Now, you got the call to come to this scene at 9 p.m., correct?
Yes.
Then you walked very quickly to get there, right?
Yes.
Then when you got back home, you transferred all your information onto this printout, right?
Yes.
Where you signed the time as 9:20 p.m., correct? And Miss Bass, to be clear, 9:20 is only 20 minutes after 9 o'clock, right?
Yes.
When you got the call.
Yes.
Now, finally, I'd like to take a look at the second point. You wrote sedan driver likely impaired or car chase reported by cop on scene. Did I read that correctly?
Yes, you did.
So, Ms. Bass, prior to your employment by the defendant, you wrote that a possible cause of the crash could have been the chase. Yes or no?
Yes.
Thank you, Ms. Bass. Now, I'd like to clarify, at this point, all you knew about the chase was that it had occurred, right?
Yes.
No other details, right?
No.
And you never learned any more details about the chase because you were fired from the Texoma Building Department, right?
Yes.
But then later on, you reached out to the defense with your own company, right?
Yes, I did.
And this was in April, right?
Yes.
And between March 12th and April when you reached out, you didn't think much about the case, did you?
No, I did not.
You hadn't done any further investigating of your own in that time, right?
No, not then.
So to be clear, when you reached out to the defense, you didn't know why that sedan had been on Fox Avenue, did you?
Well, no, I did not.
You didn't know exactly how the chase had unfolded, did you?
No.
You didn't know when the chase had ended, right?
No, I did not.
And you did not know that it was Bonnie Barrow that had chased Kenton Kane up and down the streets of Texoma, did you?
No, I did not.
But then, the defense, as you mentioned on direct examination, specifically asked you to testify about the nature and foreseeability of the events leading up to the crash, right?
Specifically an engineering perspective on the nature and foreseeability.
Yes, but of the events leading up to the crash, correct?
An engineering perspective, yes.
On the events leading up to the crash, the events, correct?
Yes.
And Ms. Bass, you'd agree, now that you know, that the car chase was part of the events that led up to the crash, right?
No, I would disagree with that.
Ms. Bass, isn't it true that before the sedan was on Fox Avenue, there was a car chase?
Well, yes.
So it did come before the crash, right?
It was before, but unrelated.
That was not my question. The car chase came before the crash, yes or no?
Yes, it did.
And this car chase, you didn't know much about it at the time, did you?
No, I did not know too much about it.
Now that you're employed by the defendant, you're getting paid $375 per hour for investigation and analysis, aren't you?
Yes, for my expert investigation and analysis.
And you're also getting paid $775 per hour for travel, preparation for trial, and testimony at trial, right?
Yes.
So, if you do the math with all the hours you've worked, you're making over $11,000 off of this case, aren't you?
Yes, for the work I've spent on this case.
Right, and this was only your second case with your company Base Structural Investigations, right?
Yes.
And just based on the media coverage alone of this case, you've received 6 other requests to consult, right?
Yes, I have.
And if your standard rates apply again, that's 6 other cases where you'll make hundreds of dollars an hour, right?
Possibly.
So that could be a yes?
Maybe.
Thank you, Your Honor. We pass the witness.
Redirect.
Brief redirect, Your Honor. Now, Ms. Bass, after being here today and hearing the facts about the car chase, has your conclusion as to who is responsible changed?
No, my expert conclusion is completely the same.
And does your pay have any effect on your testimony today?
No, it has no effect whatsoever.
No further questions, Your Honor. I pass the witness.
Recross.
Very briefly, Your Honor. Now, opposing counsel just asked about the pay you make from today. To be clear, this money you make is getting paid to you by the defense, right?
Yes.
Thank you, Your Honor. We pass the witness.
The witness may step down.
Your Honor, at this point, the defense rests.
Both sides close.
Yes, Your Honor.
All right, you may take a minute before closing argument. Thank you. State ready to
Yes, Your Honor.
present your closing argument.
Now, before I proceed, maybe reserve up to a minute for rebuttal.
You may.
May it please the court, opposing counsel, and members of the jury. Actions have consequences. On the night of March 12th, Bon Barrow decided to take the law into her own hands. And as a result of her actions and her actions alone, an innocent woman is dead. Throughout the course of this trial, the testimony and evidence that we've presented to you can only lead to one conclusion: that Bon Barrow is guilty of attempted kidnapping and felony murder. Now, according to the laws of the state of Texoma, one commits the offense of attempted kidnapping when they commit any purposeful act that strongly corroborates their attempts to kidnap. That's exactly what Bon Barrow did. Members of the jury, you heard her plan. Miss Barrow wanted to perform a citizen's arrest of Kenton Kane. So, she staked out Mr. Kane's house for days. Then, on the night of March 12th, the defendant had her chance. In an attempt to catch Mr. Kane, Miss Barrow knowingly instigated a reckless, dangerous car chase through these crowded streets of downtown Texoma. You also heard from Kenton Kane and how, under the threat of a gun and zip ties, he was driving to save his life. Now you also heard from Dell Boone and how, in this communications log, she clocked both cars, driving at insanely dangerous speeds as a result of that chase. Now, the defendant's actions on the night of March 12th are not only reckless, dangerous, but downright illegal, as citizens' arrests are not lawful in Texoma. This means that what Miss Barrow did that night was attempted kidnapping, plain and simple. Now, the defense has alleged that Miss Barrow voluntarily abandoned the chase before T.D. Lee was killed, but you've heard her testify today that she only stopped the chase after she heard the sirens from the police cruisers and saw the lights from the police helicopter. Now, since she abandoned the chase to avoid being apprehended by law enforcement, this does not constitute voluntary abandonment. The evidence is very clear, members of the jury. Bon Barrow is guilty of attempted kidnapping. But that's not the only thing she's guilty of in trial today. Miss Barrow is also guilty of felony murder. According to the laws of the state of Texoma, one commits the offense of felony murder when they attempt to commit a felony, and while doing so, they commit an act that is clearly dangerous to human life. That act causes the death of another, and that death was a natural and foreseeable consequence of that dangerous act. Trial to you today, we proved each of those four elements. First, you saw that Bon Barrow attempted to kidnap Kenton Kane. Next, you heard from Jess Newton, Dell Boone, and even the defendant that while trying to kidnap Kenton Kane, she started a reckless, dangerous, and illegal car chase. You also saw that car chase, that T.D. Lee's death, was a natural and foreseeable consequence of that car chase. Miss Barrow realized it was dangerous, yet she still continued on. Now, what does the defense have to say? The defense has alleged that Kenton Kane is the one who's responsible for the death of T.D. Lee. The defense has alleged that Tia Deely died because she was in a construction zone late at night. And that she died because these bricks were left upon the scaffolding when they shouldn't have been. Members of the jury, I'd like to ask you a question. Would any of that have mattered if Bon Barrow wasn't chasing Kenton Kane up and down the streets of Texoma? In other words, they're blaming the victims here. Kenton Kane, who's a victim of the attempted kidnapping, and Tia Deely, a victim of the chase that ensued. Members of the jury, we are here today for one reason alone. Because, as a result of Bon Barrow's reckless, dangerous, and illegal actions, a young woman has died. Now, the testimony and evidence that we have presented to you can only lead to one verdict. That Miss Bon Barrow is guilty of attempted kidnapping and felony murder. Thank you.
May I proceed?
Yes, defense, closing argument.
Your Honor, opposing counsel, members of the jury. At the beginning of today's trial, Miss Espinette told you about a nursery rhyme that begins when an old woman swallows a fly. Of course, the fly itself would be harmless, as after the woman has swallowed it, no one expects her to swallow a spider, much less a cat, much less a horse. But it is these unforeseen events that finally lead to the woman's death. Today, the prosecution has chosen to blame Bon Barrow for the death of Tia Deely, because they claim Miss Barrow set off a chain reaction that ended with the victim's death. They've chosen to blame the fly for the death of the old woman. But members of the jury, correlation is not the same as causation, and a series of disconnected events is not the same as a chain reaction. Now today, the prosecution had the burden to prove every element of their case beyond a reasonable doubt, and they have failed to do this. The evidence has shown that Miss Deely's death was not a foreseeable consequence of Miss Barrow's actions, because following Miss Barrow's initial attempt was a series of disconnected events, each one less foreseeable than the last. First, you heard that no one was supposed to be in the construction site where the victim died in the first place. And an expert who examined the scene noted that the victim would have had to wander around high barricades into the downtown street to access it. Should Miss Barrow have foreseen that? Next, this expert told you that the immediate cause of the victim's death, the cubes of bricks illegally left on the scaffolding, should not have been there either, as they were a direct violation of code. Should Miss Barrow have foreseen that? Most importantly, it was the arms dealer, Kenton Kane, who crashed into the scaffolding, not Miss Barrow. This arms dealer has tried to claim that he was only driving recklessly because he believed he was being chased. But even he admitted that after leaving the alley, he never saw the defendant again, and yet continued to drive recklessly through the downtown streets. Should Miss Barrow have foreseen that? Finally, over a minute after Miss Barrow abandoned her attempt, the arms dealer reached for his phone, knocking it onto the floor. But instead of stopping his car, he bent down, taking his eyes off of the road, which is when he crashed into the scaffolding, killing the pedestrian. Now, Miss Monty Condon had just told you that actions have consequences, and we agree. But it was the defendant's action of abandoning the chase not out of fear of police, but out of a desire to prevent further harm. It was that action that stopped any sort of chain reaction. And it was Kenton Kane's action that pushed it back into motion. Now today we've also taken on our own affirmative defense. That is, if we have proven, and we have, that it is simply more likely than not that Miss Barrow abandoned the chase before the victim's death, then you must return a verdict of not guilty. The victim's friend herself told you that she saw Miss Barrow's van driving away before her friend died. What's more, there was concrete evidence stored on Miss Barrow's phone that would have corroborated her timeline. But that evidence was recklessly destroyed by a state investigator who is connected to today's case. Further, even the prosecution can't decide what they want you to believe. Members of the jury, there is no doubt one of their witnesses lied to you today, under oath. Kenton Kane told you that the person he saw get out of the van was the driver, Bon Barrow, that he never saw Jess Newton, and that the person who he saw was holding a gun. But Jess Newton told you that it was him who jumped out of the van, but he wasn't holding a gun. Further, Kenton Kane told you that his headlights were off, in direct contradiction to the testimonies of both Del Boone and Detective Wilson, two investigators of the state. Members of the jury, if the prosecution can't decide on their own story, why should you? The prosecution has failed to meet their burden of proof. They've tried to frame a disconnected chain of events as a chain reaction. But members of the jury, the fly didn't kill the woman, and neither did Miss Barrow. Find Bon Barrow not guilty. Thank you.
Rebuttal argument?
Yes, Your Honor. Now, you heard Mr. Fredericks allege that the death of T. Dealey wasn't foreseeable, but that simply wasn't true. What else was Kenton Kane supposed to do when hemmed to the curb and approached with a gun and zip ties? Now, Bon Barrow started a car chase where the cars were driving at 60 to 80 miles per hour in a crowded downtown area where the speed limit is 35 miles an hour. It's perfectly foreseeable that in this situation, Bon Barrow's car chase caused the death of T. Dealey. Now, actions have consequences, and Bon Barrow needs to face the consequences of her actions. And because of the testimony and evidence that we have presented to you, there can only be one verdict: that Bon Barrow is guilty of both attempted kidnapping and felony murder. Thank you.
Right, I invite you to give both teams a round of applause. Are there anybody have any reason to believe there's been a material rules violation?
No, Your Honor.
All right.
No, Your Honor.
Okay, thank you. Members of the jury, you are retired to deliberate.
have at least one of our third place teams here, and that is third place this year, last year's Penny State champion, Booker T. Washington. The other third place is the team from Dallas, Woodrow Wilson. Is anybody here from Woodrow? I didn't see anybody, so we're gonna go with. Okay. At this point, I would like your jury to introduce themselves to you. Why don't we start, Jonathan, with you, and we'll all the way around and end up with Brad, okay? Yeah.
Hi, my name is Jonathan Childers. I'm a business trial lawyer and partner at Linden Beaver Hurst and Schwayman here in Dallas.
Hi, I'm Joe Butcher. I'm the president of the Bar Association. I'm a firm legal group. I know
Hi, I'm Judy Golden. I'm a partner at the patent litigation firm here in Mount Derby, and it all just getting better every year.
Hi, I'm Ron Resty. I am the American Family and Appellate Law, so I did law, obviously, and I'm also a coach for another region's, not my biology yet, I don't make mistakes. I'm really happy to see these three kids do such a wonderful job.
I'm Todd Lawrence, and I have a law firm down to the same law firm, which is making Austin.
And I'm Brad Johnson, I'm with Ashmore and Ashmore out of Rockwall, and I do predominantly family law.
And in this group, you've got at least a couple that have judged many rounds with Jim and Tom. And when you throw in Julian and Jamie and Brad, there was a ton of trials that have been judged this year by this group. So I'm going to turn it over to Justice Myers to explain how we do this and show you one to Bert.
Well, I'm Justice Myers, and I've judged mock trial for many, many years. I'm a retired justice on the 5th District Court of Appeals. Before that, served as a criminal district court judge. And you all are amazing, and I agree, you just get better every year. So it is my honor to now tell you who our second place winner is, and that is Frisco CTE. The ballots were split 7-4, and our first place winner is Covenant Classical School.